Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at some principles for deprivation of citizenship appeals following the judgment of the Supreme Court in Begum. And what I want to do is look at a case from the upper tribunal called Hysaj. I don't know if I'm pronouncing that right. It's 2021 UKUT 238, and it's a decision of the president that came out on the 8th of September 2021, sitting with the vice president. And in this case, what they try and do is sort of synthesize the principles to be applied in deprivation cases after the recent case law. Now, this is just going to be a bite-sized video. In some of my upcoming webinars for various training providers, and you can find the links below in the description to this video, I'm going to cover deprivation of citizenship in more detail and devote a whole webinar to it. But just to summarize the principles for those practitioners who've got upcoming deprivation cases, because over recent months, we've certainly seen an increase in deprivation decisions from the Home Office and appeals coming through to the first tier tribunal and to the upper tribunal. So this is the case. I'll put the link for this case below this video, and you'll see there that the head note summarizes the principles to be applied following the recent case law. So if you look at on screen, you've got the references there. The first one is to KV. In KV, Lord Justice Leggett set out some principles to be applied in deprivation cases. Aziz was the Rochdale grooming case, and that gave some further guidance on what to do in terms of Article 8 and deprivation. Then you've got Hysaj. Hysaj was the case that went all the way up to the Supreme Court and then came down back to the upper tribunal, and that was the litigation where initially the Secretary of State had pursued nullity action against these individuals, but ultimately they accepted that was wrong and then later pursued deprivation action. Then we have the Shamina Begum case. That's really the landmark decision that has moved the goalposts, and that's the Supreme Court judgment and the judgment of Lord Reed there in Begum from this year, 2021. And then the most recent case, a Court of Appeal case called Laci or Laci from Lord Justice Underhill. That particularly looked at the principles regarding delay in deprivation cases. Now, the important thing coming from the Begum judgment is the Begum judgment focused on the fact that deprivation is a discretionary decision, and the discretion is vested in the Secretary of State. So ultimately, when appeals come before the tribunal should look at them on a rationality basis, on a Wednesbury basis. Has the Secretary of State taken a decision on a reasonable basis? Have they considered all the relevant evidence? And rationality principles apply. Although they did say where there's a question of human rights, it's for the tribunal to assess that themselves. So look at the head note. Head note says this. Head note 1, the tribunal must first establish whether the relevant condition precedent specified in 42 or 43 of the British Nationality Act exists for the existence of the discretion whether to deprive the appellant of British citizenship. 42 is conducive to the public good cases. That's what Shamina Begum was. 43 is the fraud or deception principles. Now, most of the cases that we do come under 43, and often, as in this case, it's people who claim to be, say, Kosovan nationals, and it turns out they were actually Albanian nationals. So they were granted asylum in a false identity, and that carried through then to nationality. Head note 1 carries on by saying, in answering the condition precedent question, the tribunal must adopt the approach set out in paragraph 71 of the judgment in Begum, which is to consider whether the Secretary of State has made findings of fact which are unsupported by any evidence or based on a view of the evidence that could not be reasonably held. So first task of the tribunal, has the condition precedent been satisfied? But even in assessing that, it's effectively a rationality approach following paragraph 71 of Begum. If that's established, the next thing that the tribunal need to look at is whether human rights are engaged, usually Article 8, and then they must decide for themselves if deprivation would constitute a violation of those rights. In doing so, head note 3, the tribunal must determine the foreseeable consequences of deprivation, but, and this is the clarification that comes from the Aziz case, but it will not be necessary or appropriate for the tribunal, at least in the usual case, to conduct a proleptic, I love that word, it's a future looking, they mustn't gaze into the future, a proleptic assessment of the likelihood of the appellant being lawfully removed from the United Kingdom. Because obviously at this stage, we're looking at deprivation, and the Secretary of State will then, if somebody is deprived, give a separate consideration to whether they should be granted leave to remain. Any relevant assessment, that's B, any relevant assessment of proportionality is for the tribunal to make on the evidence before it, which may not be the same as the evidence considered by the Secretary of State. So when they're assessing proportionality, they look at all the evidence before them at the date of the hearing. But in assessing proportionality, the tribunal must pay due regard to the weight that will normally lie in the Secretary of State side of the scales in an Article 8 balance, given the importance of maintaining the integrity of the British nationality law in the face of attempts by individuals to subvert it by fraudulent conduct. So if fraud is established, that's going to weigh heavily in the proportionality scales. 5, delay is relevant to either under 42 or 43. So it's relevant to proportionality, applying the judgment of Lord Begum in EB Kosovo. And this comes from the Laci or the Laci case from the Court of Appeal. But if the delay was caused by the Secretary of State's mistaken approach to nullity, because some of these cases there's been delay because initially the Secretary of State wrongly pursued nullity, that's from the Hysaj case, that delay is not going to be relevant in the proportionality assessment. If deprivation would amount to a breach of human rights, this is point 6 of the head note, the tribunal may allow the appeal. Sorry, if the deprivation would not amount to a breach of Section 6 of the Human Rights Act. So obviously, if human rights are breached, the appeal would be allowed. If human rights are not breached, the appeal will only be allowed if the Secretary of State has acted in a way which no reasonable Secretary of State could have acted, has taken into account some irrelevant matter, has disregarded something which should have been given weight, has been guilty of some procedural impropriety, or has not complied with Section 44. That's the provision preventing statelessness. So if the conditions precedent's been established, look at human rights. If you don't win on human rights, it's only going to be on these narrow rationality grounds that your appeal might succeed. And of course, the Secretary of State, paragraph 7 of the head note, must have regard to the nature of the discretionary power and the Secretary of State's responsibility for deciding whether deprivation of citizenship is conducive to the public good. And that's obviously the point that was emphasized by the Supreme Court in the Shamina Begum case. So this was a case, as you see from the judgment, of an Albanian who claimed as a Kosovan, and this was also a case where there was delay, but it was delayed due to wrongly pursuing nullity action. Interestingly, this is another case where permission had to be granted using a CART JR. So another case emphasizing the importance of having the CART JR available. The tribunal go through the principles from KV Sri Lanka, paragraph 15. So there's the principles in paragraph 6 of KV Sri Lanka. They were modified, as I said, by Aziz in terms of not undertaking this proleptic assessment in terms of Article 8, but more fundamentally, they must now, paragraph 17, be read in the light of the Shamina Begum judgment, and Lord Reed's decision is set out there at paragraph 19, and the nature of the sort of rationality review in appeals, save for where human rights are raised, and then there is where the tribunal need to consider matters for themselves. EB Kosovo delay principles apply. So there's those 3 delay principles. First, delay, somebody develops more ties. Secondly, the sense of impermanence goes away the longer somebody's stays and there's delay, and the expectation grows that they'll be allowed to remain. And thirdly, which is the important point, is that delay can reduce the weight to be given to the maintenance of immigration control. And then they set out the paragraphs from Laci where delay was a significant factor in that case. You can see a worked example effectively from Laci of how delay impacted that case. So they summarize at paragraph 29 the legal principles against decisions to deprive. So before returning to the present case, we shall attempt to reformulate the principles articulated by Lord Justice Leggett in KV Sri Lanka in a way that takes into account Aziz, Begum, Hysaj and Laci. In the light of Lord Reed's judgment in Begum, the reformulation needs to highlight the fact that in practice, where there is no issue regarding the conditions precedent, so where that is established, and obviously that's the first thing that must be established, the tribunal's starting point is likely to be the ECHR and compatibility with the Secretary of State's deprivation decision with their obligation under Section 6 of the Human Rights Act. So human rights first. If the issue is determined in favor of the appellant, then the appeal must be allowed. Otherwise, the tribunal will consider whether to allow the appeal according to the principles set out in paragraph 68 to 71 of the judgment of Lord Reed in Begum. So you can see that they're set out earlier in the judgment, and these are the rationality principles which we've gone through. And then they go and look at the facts of this case itself and find the first-tier tribunal found no error. The first-tier tribunal did not commit an error of law in dismissing the appeal. So that's really a quick summary of this latest decision, which seeks to synthesize KV Sri Lanka, Aziz, Hysaj, Begum and Laci, and give some principles for judges in how to undertake deprivation of citizenship appeals. As I said, I'm going to go into more depth in my upcoming webinars and seminars into deprivation, because it is a significant area now of practice where there's quite a bit of case law. And obviously it's a different approach than dealing with, say, an Article 8 normal appeal when you're considering removal. So have a look at the links to those webinars, which are below this video. But thanks for joining me. I hope that's helpful.